Thank you. Thank you all very much. Thanks. Please be seated. And before we start, we've had a minor problem with the wasps in the courtroom here over the last couple of days, and I don't want to alarm anybody, but I just want to make the point that if while you're arguing, or even if you're not, if you're at the table and you have a concern, we'll take a recess and try to. BGS was supposed to be here last night. I think they were, and early this morning, and took care of it. But just in case, I wanted to make that point. So we'll accommodate whatever concern you might have. So having said that, will you call the case, please?
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Samantha Granger, case number 24 AP 083. Representing the appellant, Samantha Granger, is Kevin Gustafson. Seated at counsel table with Attorney Gustafson is Samantha Granger. Representing the appellee, Vermont Board of Bar Examiners, is Ryan Kane. Seated at counsel table with Attorney Kane is the chair of the board, Patricia Turley.
Thanks very much. Good morning again, everybody. Counsel, if you would, come on up. And for the record, please introduce yourself and identify your client, and then go ahead.
Good morning. May it please the court, I'm Kevin Gustafson, and I represent the appellant Samantha Granger.
Thank you very much.
We're here today regarding Ms. Granger's seeking to admission to the for licensure in Vermont after her successful passage of the uniform bar exam on her 6th attempt. The issue before the court today is essentially whether or not Rule 13, which limits the number of attempts that an applicant can take to 4, is actually waivable. The grounds for this assertion by Ms. Granger is that the court outlined in Sarzan versus the Vermont Bar Board Examiners that if the strict application of one of the rules for admission would lead to an unreasonable result, then there is, if not explicitly in the rule, at least an implied waivability.
Is there an implied waivability on 270?
On 270, meaning
on the score of
270? I would say no, because the rule regarding the actual number of the score, if an applicant were to get a lower score than that, that would not lead to an unreasonable result. Obviously, I think the applicant who gets a 269 may feel it's unreasonable, but that strict setting of the score is, I think, a different representation of competence than the number of times in which an applicant were to take the actual exam. So that is a standard that is much more reasonable, and it wouldn't lead to an unreasonable result if an applicant was denied for a score that's below what the rules.
So the cut score is a hard line, but the amount of times is a soft line?
Yeah, the idea being that if the score being a hard line is a better representation of competency than is the number of times a person takes the actual exam.
Is the number of times the person takes the exam any reflection on competency?
Yes, and this court has found in Ray Oden that there is a rational connection between the number of attempts. So the argument is not that there isn't a rational connection. It's the question of reasonability, because the rule in Sarzan is that if a strict application of a rule leads to an unreasonable result, then at least there's the potential for a waivability of that. And so,
but Sorensen wasn't tied to competence, though.
No, I mean there was at least discussion in Sarzan about a question of whether or not it was a substantive, aspect of competency. But I do think that the general principle in terms of the unreasonable result still applies. So whether or not it's a substantive or even ancillary, I mean, that's not a principle stated in Sarzan. And the real principle is we're looking at the result and understanding whether or not the result is unreasonable or not, in terms of the question of whether or not there's a potential for waivability. So it's not necessarily saying that the rule wouldn't apply, but simply that there ought to be a process like other rules, particularly in Rule 13, in which upon the request for a waiver and a showing of good cause, that the strict rule could be in principle waived, not
Well,
only MPRE scores, sorry.
No, I'm sorry, I don't mean to interrupt you. But the interplay between 9 and 13 is what interested me. And the appellee, I'm sure as you know, argues in their brief a rationale for the difference between how the board approaches those two types of examinations or applicants, I guess a better word for it. What's your response to that?
I find it a bit difficult to understand what the board is actually attempting to do. It appears to me that the idea that there's a bit of a relinquishment of control based on the board, if an applicant decides to not take the uniform bar exam in the state, but to take it in a different state.
Well, they talk about the opportunity ahead of time, prior to the applicant taking the exam, that the BBE has an opportunity to consider whether the applicant had improved their exam preparation such that a subsequent passing score could be attributed to an increase in the applicant's competence. That's under Rule 9. But under Rule 13, they don't make this change, the appellee argues, for transferred UBE scores because they have no authority to limit who could sit for the exam in a foreign jurisdiction, and thus no pre-administration review was possible. So what do you say about that? It seems to me that that's a reasonable rationale.
I think that there are two parts of the answer to that question, Chief Justice. The first is that in this particular case, you have an applicant who did eventually pass the uniform bar exam. And so in some ways, what test preparation was or wasn't done prior to the passing test is obviated by the fact that the test was passed and that the score was achieved to a degree that was sufficient to get to be admitted by a score transfer. And so what we're talking about is if you're taking it in Vermont, which the Board of Bar Examiners administers, then they get this extra bit of control, and it's not even clear exactly what constitutes.
Well, I think it's information. It sounds like it's information. It's what they're getting. More information, yeah.
And, I think, again, that the question to me is, it's going to be such a fact-specific or even individual analysis as to what would constitute better test preparation at a fifth. And then, we do have, and it's discussed in the Odin case too, about there's a statement in the comments to it that the board would not even allow a sixth attempt, and the court said that's not an enforceable rule. And so frankly, to me, it seems as if the board is attempting to wanting or actually asserting that they have more control when for tests administered in Vermont, which I'm not saying there's no rationale to that, but I do think that in an instance like what we're presented with today, in which the person who's seeking the application passed the test, I don't see the necessity or the logic in the inability to have had to examine what the test taker was doing prior to that passing test has to do with competency to practice law. It may have competency regarding the bar exam, but I do think that the court would likely recognize that there is a difference between passing the bar exam and practicing law.
But aren't you really saying, when I have a client who has a passing score on the bar exam, that should be the end of it? Isn't that really what you're saying? Because what's the difference between obtaining a passing score on the 6th try or the 26th try? The person is trying to transfer in a passing score.
I mean, our argument would be that if the rule maintains, that Rule 13C retains, and there is this floor limit, that what we're seeking is not a removal of that rule at all, but at least the possibility for some kind of waiver. And then there can be a process by which other aspects of the applicant's competency can be examined, so that it's not only that they passed the bar or only how many times they took it. It's not that. It's a more holistic review of the applicant, which is partly what the rules are intending to do. That's why you have a character and fitness. That's why you have other measurements in terms of whether or not you should be able to be admitted as an attorney in Vermont. This is the only rule that creates this bright line that if you take it more than 4 times, and you did get permission by taking it in Vermont for a 5th or 6th time, that we can just per se deny you. I think without the waiver ability, and that's all that Mrs. Granger was attempting to ask the Board of Bar Examiners, was simply to review other, indications of competency to waive that provision rule like you can for the MPRE and like for Stale School.
So you mentioned bright lining. So I'm going to go back to my original question. Isn't 270 a bright line?
Yes, but it is a bright line that is a different representation of competency. It's actually achieving a certain score on the test rather than the number of times that test is taken.
But we've already said the number of times that it is taken does have a bearing on competency.
Yes, it does have a bearing, but a different bearing than the score that one gets. If you take the bar exam 12 times or 20 times and never pass the bar exam, there's an indication of competency. I would say specifically regarding the bar exam, not so much actually the ability to practice law, because I do think there's a growing body of scholarly work and sort of critiques of the bar exam in general. There's a next gen bar coming up that's going to be different than the bar exam that's administered.
Yeah, to that point, California has left it behind, as I understand.
And other states, Wisconsin doesn't, if you're a Wisconsin graduate, you don't need to. There are other ways in which competency is determined, the number of times you take the test, in my view, is not, it may bear on competency, but it's certainly not as important either as the score or in fact other measures of competency. And in this case, we have an applicant who is years of experience, post-law school, was a clerk for a judge in Alaska, who actually acted as a magistrate in Alaska, someone who has ample, recommendations that they could have submitted to the board at the board, asked that, looking at, understanding that it has a waiver ability of Rule 13C under Sarazin. So you have a situation in which the application of one subpart of the rule for admittance via transferred UBE is denying an otherwise fairly obviously competent and capable attorney from practicing law in a state that desperately needs attorneys, which turns on public policy questions about whether or not the rules are there to prevent via bright line rules attorneys who may otherwise be competent, or whether or not the rules should be understood as ensuring that they can protect the citizens of Vermont from incompetent practitioners of law, but also to have it able to understand the different circumstances of different applicants, especially having had a pandemic not too long ago.
No, I
So
understand.
why doesn't this, go ahead. Why doesn't the argument you've just made apply in any case? And including somebody who's got a 269 or a 268 or a 267, all the things you just said would seem to apply equally in that situation.
I think that if personally, from my perspective, the instance of bright line rules is preclusory in a way that is not helpful means to judge the competency of an attorney. So I think the 270 rule, you can make the argument is a better measure of competency because that's what's considered the passing score, but that is itself also arbitrary. And so personally, a waiverability of any of the rules, so long as it brings in other questions of competency, does not seem to be something that would seriously risk the entrance of a new flock of incompetent lawyers into Vermont. What it would actually do is allow people who would otherwise not meet certain bright lines to be able to have other means of representing their competency, which again, I think should be the purpose of the board of not necessarily bar examiners, but a board of licensure, because we're understanding that a test, particularly the bar exam, is not always a good example of one's competency to practice law. You could do very well on the bar exam and essentially being an incompetent attorney. And so I do think that the argument is reasonable that rules can certainly be set. They can be the measure by which the court can analyze an applicant's application, but that waiverability, so long as that waiverability includes reasonable criterion on evaluation, is perfectly reasonable. And I would like to reserve the remaining.
Okay, all right, thanks very much. We'll hear from counsel for the appellee, please. And if you would, introduce yourself and identify your client.
Thank you very much. Good morning, Your Honors, Mr. Chief Justice, and may it please the court.
Thank you.
Ryan Kane, Deputy Solicitor General, on behalf of the Vermont Board of Bar Examiners. This case is governed by the plain and unambiguous language of the Vermont Rules of Admission for the Bar. Those rules provide for waivers of some but not all provisions, and this court has already held that it should apply the traditional rules of statutory construction in interpreting those rules. And those rules dictate that omission of a waiverability provision in Rule 13C was intentional and must be upheld. The board was sympathetic to the applicant's situation and ultimate story, but concluded that there was simply no provision in the rules that allowed for a waiver. I'd like to go to the point that was just being discussed and articulate this in the briefs as well, but there would be implications to providing for waiverability without any articulated standards for considering such a waiver for any provisions of the rules of admission, including the score rule. There are bright line tests established by the rules, and to throw those out or to allow for somebody to argue before the Board of Bar Examiners that they should subjectively look at all these other factors would just open up the board to burdensome requests, many probable requests, without clear and articulated standards by the rules.
The board is entirely free to come up with standards for the exercise of its discretion. It's operating some rules now with waiverability attached to them. So why not this one?
Well, certainly the board can promulgate rules, and ultimately this court is the court, the body that adopts and finalizes those rules and determines them. So certainly the board could allow for waiverability of everything, including the score of 270, including any provisions of the rules of licensure. The reason that there are bright line tests and there are gates, these gatekeeping functions, is to ensure both that those who are admitted to practice law in Vermont are competent to do so. It's an extremely important role that a lawyer plays in representing clients in this court. And Vermont has one of the highest standards for the test. 270 is the highest of any state. There are other states that also have 270, but this court and the board has rightly determined that these are substantial.
This particular rule about the number of times you take it and so on, I mean, this particular case seems to be an exercise in form over substance.
I disagree, Your Honor. This court has already held that the 4-attempt limit goes to competency, is substantive. It held that in Odin.
Well, there may be a rational connection to it, but again, I'm having a hard time understanding why there ought not to be some flexibility here and discretion exercised by the board.
There is discretion exercised on the board under Rule 9 to sit for the bar exam in Vermont, and that is also tied to competency. It says if you've failed the bar exam for a certain number of times, Vermont is 4, some jurisdictions it's as low as 2. Of the UBE states, I believe 15 have a limit. So Vermont has set it at 4 and said if you failed the bar exam 4 times, that is an indicator that you lack sufficient competency. You can overcome that indication by saying, I've improved my skills as a lawyer. I've done more studying. I've done more practice. I've done these
Wasn't that
things.
done
Why
here?
should this be a rebuttable presumption?
Because then, again, it requires, certainly this court could suggest that the board revise the rules, but I think there has to be some clear articulated standards for an after the fact assessment, again, after a passing score. Because I think it's pretty hard once you've passed the bar exam, whether it's on your 6th or 26th time, you can make the argument that I think Justice Eaton correctly made, that that's what matters. I passed the bar exam. You said this is the test and I passed it. And so I think there has to be what makes the most sense and what the rules require is some pre-test adjudication of whether or not that test, whatever the results are going to be, should be.
Wasn't the same thing done here?
Excuse me, Your Honor?
Wasn't the same thing done here
Which
by the applicant?
effectively,
Effectively, even though the test was taken in Maine,
Mhm.
there was compliance with the standard that Rule 9 sets out. Wasn't that exactly what happened here?
I don't think so, Your Honor. Again, the record, the factual record, I don't think is, the board ruled that 13C is not waivable, and that's the entirety of the decision. But in fact, if you look
Well,
at,
it's this,
But if you-
it's the interplay, as I said before, when your opponent was arguing, the interplay between rules 9 and 13 is what interests me. Because
Yes.
you've got two, one, you've got a bright line rule with some rationale to it, which makes some sense. But the other one, you've got waiverability based upon providing information that it appears as though the applicant here had provided, and the board otherwise might have been well aware of because she had taken the test here in the state of Vermont as well.
So exactly, Your Honor. And so I think factually, again, that wasn't the basis for the board's decision, but the appellant did fail the bar exam, the UB 4 times, apply for a waiver under Rule 9C to sit for the bar exam in Vermont a 5th time. Articulate the standard for granting that waiver is set out in the rule as demonstrating, improving their study taking abilities such that it would be, worthwhile to score. And ultimately, it's in the records. It got the exact same score as the 4th time, and in fact, the 3rd time, 265, 265, 265. So they're granted the waiver on the basis that they had improved their study abilities, which goes to competence, and then achieved the same score. So presumably, the basis for that waiver, and this court held in Odin that there's no limit on the number of waiver attempts. The appellant could have applied under Rule 9C, demonstrated good cause to sit the exam 6th time in Vermont, and the board could have determined whether or not a waiver was appropriate under those circumstances. And what the appellant did was circumvent that waiver process that the Board of Bar Examiners has to determine whether or not pre-application of the test that the test would likely overcome the presumption of lack of competency based on the prior failures, and instead went to Maine. But at this stage, the appellant's free to again apply for a 9B waiver and sit for the exam again in Vermont and maybe articulate that they did something different between the 5th failure and the 6th.
The thing they did different was to comply with the 270 pass rate.
Right, well, that's exactly, and that's always, I think, gonna be the difference between is it gonna be, well, this time I passed. And I think the fundamental basis for the 4 attempt rule is that at a certain point, and Vermont has set it at 4, the repeated failures to achieve a passing score is more indicative of somebody's competency than one ultimate success.
But it's the exercise of this discretion is what I'm interested in, and how that effort is undertaken and whether or not it's consistent in the way in which the rules are being applied. And again, I understand the difference between the rationale for Rule 9 and Rule 13 as it's spelled out in your brief. But can you walk us through any of the detail about how the board is applying the discretion it has under Rule 9? Are you aware of any of that, any facts?
No, Your Honor. And again, I mean, those facts.
Is it all on paper? Do they have hearings of any kind? I mean, how is it exercised? Do you know?
I don't know.
Well,
Yeah.
I'm not gonna.
And
we're not gonna
again,
take
I think,
here, but-
but what's important, there are articulated standards for assessing a good cause waiver under Rule 9 established by the rules, which I think goes to another important function of the rules, which is not only to ensure competent attorneys, but is also to have an administration of the process that's clear to both applicants and to the Board of Bar Examiners, that people know what the rules are, they know what they need to comply with, they know that they have to get a score of 270 on the UBE to be licensed in Vermont. And the availability of those clear rules makes the process, administered in a reasonable way. It's not.
There is an avenue for her to obtain admission based on what she's already done as far as the bar exams by practicing in Maine for a requisite period of time and then coming in as a practicing attorney.
Absolutely, Your Honor. That's absolutely correct. And if anything, post-COVID with the availability of remote work, that opportunity is probably more available today than it ever has been before, that somebody could work and be licensed and practicing successfully in a jurisdiction like Maine, which actually has, lower reciprocity requirements. And as I said, another option is to apply for a Rule 9 waiver.
So is there a rationale for the front loading? So if it's front loaded under Rule 9, asking for permission to take the test versus taking the test in a different state and saying, hey, I've got the pass, I've got the cut score now. Is there a rationale for that?
Yes, I think it goes to, I've been trying to think of a better analogy that doesn't involve golf, both because I'm not a golfer and to avoid the cliches of attorneys being golfers, but I'll stick with it because I haven't thought of anything better. If I'm looking for a golf partner and I set a particularly difficult golf hole as the test, I say, if you can get a par on this hole, I'm confident that you're competent, right? And I give you 4 attempts at that, and you get a double bogey on that hole 4 times. I'm going to say, I'm sorry, you're not the golf partner for me. If you come back and say, I'd like to try again, I'm going to say, okay, but what's changed? You say, oh, I took a bunch of golf lessons. I got a private coach. I, did all of these things to improve my golf game. I say, okay. And then you birdie it or you get a par. I would have a reasonable basis to say, you've improved your golf game. If you just come back and say, hey, remember that hole I got a double bogey on 4 times? I got a par on it. That's not going to be enough for me to overcome those prior failures to say, I'm confident that you're competent to be my golf partner. And the stakes in that are admittedly very low.
Very picky, you're very picky on your golf partner.
But yeah, no, exactly. But the competency to practice law in the state of Vermont is an extremely heavy burden and an extremely big obligation. And I think that
And this applicant has really demonstrated it, hasn't she?
the board.
Experience, I mean, this is not a situation in which we're really concerned that the overall goal of bar admission is being frustrated by somebody who's looking to come into the bar who's incompetent. That's what's so troubling.
But that's equally true of somebody who got a 269 on the test 4 times and could say, or somebody who got a much lower score. I mean, there certainly is criticism of the bar exam.
This case is not about somebody who got a lower score. This is a case about somebody who got the score that we accept.
Okay.
Our very high standards here in Vermont.
So it could, but again, that's equally true of somebody who got it on their 10th attempt or their 20th attempt or their 26th attempt. The 4 attempt limit this court has held is tied to competence. And I think that's important. The point that you're making is, I think, equal with respect to the 270 score and the 4 attempts rule. Both have been set as bright line tests for competence. The failure to meet that test, there's certainly going to be situations where that gate keeps somebody out of the bar who might perfectly be a competent attorney. But the rules require there to be some bright line tests in order for the fair and just administration of the admission process. It can't be that anybody who can demonstrate through years of work. And again, but there's the office study program. Again, the rules have been set by this court. They are what they are. There is a bright line rule in 13C that is not waivable under the clear, non-ambiguous language of those rules. And the Board of Bar Examiners properly concluded that it did not have the authority to waive that rule. The rule is reasonable, as we've discussed, I believe. And for those reasons, this court should affirm the decision below. Unless there are any further questions.
Okay,
Thank you very much.
thank you very much. Does the appellant have time?
The appellant has 1 minute and 43 seconds remaining.
Okay, counsel.
So, Mr. Gustafson, why didn't your client apply for a waiver to sit for the 5th time in Vermont?
The applicant did actually apply for a waiver on the 5th time, was granted that
Oh,
waiver.
that, I
And
saw
so
that
it's
one.
the 6th time that's actually the issue, and the reason that.
Thank you. So why didn't she apply for a waiver the 6th time?
Based on so although the Odin decision does say that the note about not accepting, like basically that there is a bright line rule that 6 times will not be admitted. And Ms. Granger was under the impression that that waiver would just not have been allowed, that it would have been denied based on that the comment in the commentary of the rule, and also based on indication she got from the board. Essentially, don't try for the 6th time. It's getting.
So is that in the record? Are you saying the board discouraged her from applying again for a 6th waiver?
The applicant's understanding both of the rule as it is commented and the practice of the board is that there's nobody who gets a 6th attempt. And so the idea was, given the uniform bar, the acceptance in Vermont of the uniform bar exam, she had the option to not.
She did not have any communication with the board on that as to a 6th attempt. Is that correct? That's what I'm trying to ask you.
It is my understanding that it was communicated, I think, in a formal email, but I don't believe that's part of the record in this case. And so Ms. Granger felt like there was no other option. She had, if she wasn't under the impression that that was just going to be a bar, like a per se denial, I think she would have applied and shown the court what she had done, which was significantly different, which is evidenced by the fact that she got an improved score on the bar exam.
So when the Solicitor General or Deputy Solicitor General says that she is trying to come in under Rule 13 as an end run around Rule 9, is that right?
I mean, an end runaround is an interesting way. It's the uniform bar exam. It's the same exam, in terms of its content, and she got a score that was sufficient. So it's not an end run. She has the option to take it in a different jurisdiction, opted for that option, and received the passing score.
Okay, thank you.
Thank
Your
you.
time has expired.